The exchange of a cultural object involves a multitude of disciplines and participants, and with each participant acting to protect their own interests or those of the institution they represent. Such an exchange may result in the object entering illicit territory. This presentation discusses the movement of the famous Ka-Nefer-Nefer mask into the illicit market and the various grey areas of legislation and ethics surrounding the case. The Ka-Nefer-Nefer mask has been dated to the New Kingdom Dynasty 19, circa 1295 to 1186 BC. It is composed of plaster, linen, resin, glass, wood, gold, and pigment. According to the Supreme Council of Antiquities (SCA), it was discovered in the burial site of a 19th dynasty noblewoman named Ka-Nefer-Nefer, inside the 3rd dynasty enclosure of Kemkit at Saqqara. The excavation was carried out by Muhammad Zakaria Ghanem in 1951 to 1952 on behalf of the Egyptian Antiquities Service, which was renamed the Egyptian Antiquities Organisation in 1971 and then the SCA in 1994. According to Angelia Selick, 1 year after its excavation, the mask was registered as Egyptian property in terms of the amended Egyptian Cultural Patrimony Law then in force. The SCA provides us with information regarding the period that the mask supposedly spent in Egypt, stating that many objects excavated by Ghanem, including the funerary mask, were held in Saqqara storerooms before being transported to Cairo Museum en route to Tokyo for inclusion in an exhibition that was never mounted. The mask was then returned to Saqqara, finally ending up in the Antiquities Department's Conservation Lab in Cairo Museum in 1966. It was only in 1973, following an inventory check, that the funerary mask was reported missing. According to the SCA, there exists clear documentation that the mask was in Egypt until at least 1966, a statement which has led to much uncertainty regarding the legitimate movements and line of provenance of this cultural object. The Cultural Patrimony Law of art-rich nations, supported by international agreements, particularly that of the 1970 UNESCO Convention, prove useful as they allow governments to claim ownership regardless of the discovery status of cultural objects, thus, according to Selick, making it the most efficient route for repatriation. The legislation governing the case of the Ka-Nefer-Nefer mask is the Egyptian Cultural Patrimony Law No. 215, which came into force on the 31st of October 1951 and was thereafter revised in 1953, Law No. 529, 1965, Law No. 24, and 1983, Law No. 117. It emphasises that all antiquities, either known or concealed, ultimately belong to the state and are required to be registered on an official inventory. This would imply that the Ka-Nefer-Nefer mask is therefore the undisputed national property of the Republic of Egypt, and if the state is unaware of its transportation out with the Egyptian border, then it should therefore be deemed illicit. According to Jessica Dietzler, although a work of researchers has helped to create a framework for analysing the exploitation of illicitly acquired archaeological antiquities and the criminal activities involved therein, significant gaps in our understanding of the trade process and actors remain. During the transit process, which may involve intermediary countries before a cultural object reaches a market of legitimacy, as was the case with the mask before reaching the St. Louis Art Museum, SLAM, said object encounters multiple actors or participators in the illicit trade in order to garner a plausible line of ownership. This could be viewed as an obscuring or cleansing of the cultural object's illicit history. According to Dietzler, most recently surfaced antiquities on the market have either 1. No find spot documentation or ownership history, or 2. Falsified or vague and unverifiable ownership history, thereby disguising the illicit item under a cloak of licitness and allowing entry into the open market. The latter is pertinent in the case of the Ka-Nefer-Nefer mask, as is evidenced through the brief consideration of the conflicting provenance provided by the US, Egyptian governments, and the SLAM as demonstrated here. Part of the provenance suggested as true by the SLAM contradicts both the Egyptian and the US government's version of provenance, as it alleges 3 acquisitions between 1952 and the early 1960s, when the mask was supposedly in transit between Cairo and Saqqara. The question then arises as to why the SLAM, in the course of the due diligence, failed to discover the alternative line of ownership, or the fact that the mask, following an inventory check, had been reported missing in 1973. The existence of two disparate provenance accounts, which actively contradict one another, almost corroborates the mask's illicitness. In addition, the fact that little detail is provided with regards to the exact dates of the changes in ownership suggests that there has been an attempt at garnering a plausible provenance. That the unbroken provenance is a rarity, the fact that the chain of ownership is unbroken from the time of discovery to the current whereabouts is in itself suspicious. I will now consider routine activity theory, RAT, which according to Dietzler proposes three fundamental components for the motivation of crime, namely 1, a suitable target, 2, a motivated offender, and 3, the absence of capable guardianship. In this instance, the target is the Ka-Nefer-Nefer mask. The motivated offender may well comprise of a host of actors participating in the intermediary countries, promoting the cultural object into the open market, and the lack of capable guardianship is exemplified by the vague provenance, and the fact that the mask cannot be legitimately accounted for by Egypt, with the open borders allowing for the undermining of its vested ownership laws. The absence of a capable guardianship is further evidenced in the mask's final stage of transit before arriving in the legitimised open market under the ownership of the Slam. According to the US Immigration and Customs Enforcement, ICE, customs laws allow HSI to seize cultural property and art that are brought into the United States illegally, especially when objects have been reported lost or stolen. However, the mask had not been reported stolen and was therefore not recorded in the Art Loss Register or Interpol databases. This is confirmed by the Slam in its course of due diligence, and so an illicit cultural object could enter the US under the provenance provided to the museum. I will now consider the market aspect of the case surrounding the Ka-Nefer-Nefer mask. For $499,000 in 1998 from Phoenix Ancient Art of New York and Geneva, an international art gallery based in Switzerland with previous involvement in illicit trafficking, the proprietors of which are Icham and Alia Belton. In order to understand the extent to which Slam purchased the mask in good faith, I will consider due diligence alongside the guidelines on the acquisition of archaeological material and ancient art of the Association of Art Museum Directors, AAMD, of which the Slam is a member and therefore accountable to. According to AAMD, the Slam was liable to carry out due diligence in accordance with the guideline procedures listed here on the acquisition of ancient art with regard to the thorough research of provenance, the attainment of import and export documentation of both source and intermediary countries, and the provision of warranties from sellers and donors. According to Selick, the Slam claims that prior to the purchase, they inquired about its provenance with the Art Loss Register, the International Foundation for Art Research, Interpol, and consulted with the then director Mohammed Saleh of the Cairo Museum. All respondents confirmed that this piece was licit, and there were no reports of the mask missing at the time of the proposed purchase. It is patent from the perspective of the museum, who views itself as the rightful owner and just owner, that it was rigorous enough in its provenance research to satisfy the guidelines. However, from the entirely alternative line of ownership, later provided by the US and Egyptian governments, it is clear that the provenance is dubious and unreliable. Moreover, its statement that the museum's investigation revealed no evidence that the mask was owned by Egypt under the applicable Egyptian law at the time of excavation, or that the mask was stolen from Egypt, seems entirely implausible. According to the Committee for Cultural Property, the Slam, in carrying out due diligence, also hired an independent scholar who reported that the mask had likely left Egypt prior to the imposition of Egyptian law prohibiting export. With the Egyptian Cultural Patrimony Law No. 215, introduced on the 31st of October 1951, there's a strong likelihood that the mask would have been in Egyptian ownership, particularly as the Slam version of provenance lists the first questionable acquisition as having occurred in 1952, following the introduction of said law. It was due to the compulsory inventory of the state as a byproduct of Law No. 215 that the mask was reported missing in 1973. Neither the absence of the mask's presence in the government inventory nor the absence of a record of its illicit removal from Egypt justifies or secures its legitimacy on the open market. knowledge gap in relation to the provenance of the mask, which could result in others participating in the potential illicit trafficking of an ancient cultural artifact, regardless of whether or not their actions were in good faith. As was the case with Islam's purchase of the mask and its consequent movement into the open market, warranties of title obtained by dealers from sellers acted to substitute for knowledge of the seller or of the history of the object. Such information should not be taken as proof of provenance, and provenience should also be considered for further corroboration, particularly in cases where there is little knowledge of the alleged previous owners of a cultural object. The provenance could easily have been faked. Hence, the existence of warranties and letters of sale alone do not justify the mask's legitimacy. Following the Egyptian government's realization of the location of the mask under the Islam's ownership and subsequent registration of the case with the Egyptian authorities, the United States government, according to Selig, attempted to seize the mask from Islam with a civil forfeiture. 3 years of legal battles between the United States government and Islam followed this initial order. The case concluded on the 12th of June 2014 in favour of Islam after appeal. The US government's case majorly failed the statute of limitations when filing for forfeiture. Islam's response to any criticism or legal discourse with respect to the correct ownership of the mask is simply, we bought it, we paid for it, it's ours, and we're going to keep it. Nonetheless, there is no avoiding the fact that, through its performance of optical due diligence, Islam progressed from being a victim of the market to a participator in the manipulation of the art market, funding the illicit trade. In many restitution cases, the 1970 UNESCO Convention is considered a way out for the market country by stating that the cultural object in question was most likely out with the source country prior to the enforcement of the International Convention on the grounds demonstrated here. Nonetheless, one must note that this is entirely irrelevant if the government of the source country in question was vested with ownership rights which were in effect prior to the UNESCO Convention. For example, in this case, the date 31st of October 1951 is highly relevant, whilst the year 1970 is not. According to Howard Spiegler and Yale Weitz, virtually all so-called art-rich countries have enacted laws, mostly in the early 20th century, declaring that anything found in or under the ground, even if not yet discovered, is owned by the government. These laws, called patrimony laws, are usually key to establishing the foreign government's ownership. Ownership law of the source country is typically the fastest route to restitution of looted cultural property. According to Gerstenbluth, when considering such law in restitution cases in the US, the 4 aspects listed here must be satisfied. Whilst at first glance these 4 aspects appear to have been satisfied in relation to the mask, thereby assigning it as under the ownership of the Egyptian government, there remains a distinct grey area as regards the exact discovery date of the object, currently estimated at 1951 to 52, and therefore possibly prior to the introduction of the ownership law, and is therefore not effective in the case of restitution. Whilst this in no way legitimizes the movement of the mask, it does add an element of confusion to the timeline of events, placing the repatriation of the cultural objects in the hands of Islam, consequently shifting a legal case into an ethical debate. According to Spiegler and Weitz, when the assumedly victimized country cannot establish sufficient evidence of its legitimate ownership, the defendant, it is apparent that there is a definite power imbalance regarding whom the law favors, with the market country, who may have acted as participant in the illicit transit or purchase of a cultural object, retaining ownership rights. Due to a lack of overarching global legislation, reacquisitions policies, and an evident ethics deficit in the international art market, cultural institutions in the acquisitions process should act to cross-reference the legislation of source, intermediate, and market countries to ensure the legality of the traded cultural objects. Centred on the notion of ethics, the organisation Saving Antiquities for Everyone, SAFE, presents an alternative ending to the debate of the restitution of the mask. Commenting on the tremendous shift in major museums and auction houses' attitude towards repatriation, such as the Met's decision to return the Euphrosyne crater to Rome in 2006, SAFE suggests the possibility or the obligation of the Islam making a demonstration of goodwill in its repatriation of the funerary mask. This could result in the potential future collaborations and loans between Islam and Egypt. SAFE proffers that Islam's insistence on keeping the object seems rather outdated, and since in this particular case there remains no concrete provenance, Islam patently still has an ethical and moral obligation to fulfill. In conclusion, cultural institutions such as Islam should assume the role of guardian over the exchange of said objects through continual due diligence on artifacts currently in their care, specifically those which demonstrate dubious provenance such as the Ka-Nefer-Nefer mask. Such action may then at least act as a crime reduction technique or deterrent to the illegal sale of cultural objects into the open market. Thank you.